So how in the world do you set up a special needs trust? Maybe this has been on your to-do list for years, but you just haven't been able to get it done. So in this video, I'm going to talk all about everything you should know about setting up a special needs trust in California. Hello and welcome to my channel. My name is Ellen Cookman and I'm an estate planning attorney who specializes in special needs planning. On this channel, we're going to talk about how to set up a special needs trust to protect your loved one who has special needs. We'll talk about the importance of setting up a trust, what's the difference between a regular trust and a special needs trust, regular estate planning, a revocable living trust, how to avoid probate, trust administration, and many other relevant topics. If this information sounds useful to you, please consider subscribing and hitting the notification bell so that you'll be notified when new videos come out every week. I'm a certified specialist in estate planning, and my law firm has helped hundreds of families navigate the complicated process of setting up their estate plan with special needs components. I'm excited to share all of the knowledge that we've learned over the years with you. So before we go into the specifics of how to set up a special needs trust, I want to talk about how the whole process works to give you a picture of what to expect. Typically, what you'll do is, if you're working with our firm, you would contact our office and set up an initial meeting. We'll send you a questionnaire to fill out, and all you have to do is type it in and press send. And then we have our initial meeting, and I have the information that I need already about you. Our meeting usually takes 1.5 hours. We have it over Zoom nowadays. It usually takes us about a month or a month and a half to draft everything. Okay, so during that initial meeting, I'll collect all the information that I need to be able to start drafting. So then we draft, and then we send you the drafts of all the documents. I also like sending a nice flow chart that kind of walks people through where things go. And I've been doing some videos based on The Simpsons on, walking you through the actual documents. They can tend to be long with some legal terms, so I really want to translate those for you so you understand more about those documents. Okay, so you'll review them, then we have a follow-up call to answer any of your questions, or you can just send an email with questions and I'll answer them. After that, we have a signing appointment. Okay, so nowadays you can actually sign online. It's called remote online notarization, and this has been very popular with many of our clients. Or you can sign before a notary in your area. Either way works. And for the will, you actually need to get somebody to witness that. So that whole process can take as little as 2 months, really depending on how quickly we can get information from you and when you sign. After that, I have a fun video on how to fund your trust. So that's really step 2. You make sure that your trust gets funded. Okay, and then we send you a closing care package with some nice swag, some fun gifts, and then also a flash drive with PDF copies of all of your documents. So with funding the trust, just a few steps that you need to take. We will prepare the deed to transfer any California properties that you have into your trust. So you'll sign those during the notarization appointment, and then we take care of recording them with the county recorder's office, and then we'll send you copies of the recorded deeds. For other assets like bank accounts, brokerage accounts, you would contact your entity, and we provide a certification of trust, which is a shortened version of the trust document, and you can give that to the entity, and sometimes they have you fill out some paperwork so to move title from you as an individual to you as trustee of your trust. So again, this process can take anywhere between 2 to 4 months, and it's for a lifetime of peace of mind. So let's talk about my favorite subject, how to set up a special needs trust in California. So there's several goals with setting up a special needs trust. One of them, and I think the most important one, is really maximizing your child's independence and quality of life for as much as possible. We also want to protect your child's public benefits, and we want to avoid the court system. And we also want to set up having someone else manage the money for your loved one. In California, if you're disabled and you turn 18 years old, all of a sudden your parents' money is not attributable to you. So now you're considered poor, you have under $2,000 of countable assets, and you qualify for a couple of needs-based public benefits. One of them is called SSI, or Supplemental Security Income, and the other one is called Medi-Cal, which is a healthcare program. Federally, it's called Medicaid. It's a comprehensive, though imperfect, healthcare system. Now, what happens if your child's going to receive an inheritance, right? If they get more than $2,000, they'll be bumped off of these very important programs for them. So what we do is we set up something called a special needs trust. And when I think of a trust, it's really a contract or an agreement. So it's between the person setting up the trust and the person managing the trust for the benefit of the beneficiary. And in this case, we have the person setting up the trust, who would be you, and the person managing the trust, who most likely would also be you, but you need to set up someone else who will take over for the benefit of your loved one. So this type of trust really works because someone else is set up to manage the money for your loved ones. And because someone else is managing the money and the disabled person can't reach in and grab the money themselves, or they can't direct the manager, who we call the trustee, to distribute money out, it doesn't count as their money for public benefits purposes. So even though they might have a special needs trust that has $1 million set up for them, but in their own bank account they have less than $2,000, they continue to qualify for public benefits. So it really is like having your cake and eating it too. It's really wonderful. So you're thinking about this special needs trust. The first thing, and I think the most important decision that you'll need to make, is who's going to be the successor trustee. So you'll be the one managing your trust, but you know that at some point you're not going to be able to. You know, your child will most likely outlive you. So we need to think who will be the best manager or the best successor trustee. And this is actually a really difficult decision for most people. And this is what keeps people up at night, because you're thinking, who's going to be the surrogate financial you? You've been advocating for your child all these years. You've been making sure that they get all the services that they need. You've been helping them to apply for public benefits in the first place. Who's going to do all of that? And if you name a family member, a lot of times people say, oh, well, you know, let's say Johnny. Johnny has a typical sister, Susie, and Susie will take care of it. Well, that's a large burden to put on another family member, especially a sibling, because Susie might be wanting to live her own best life. She might move somewhere else. You understand the challenges that you've had raising Johnny. Do you really want to put that on your child? And also, another thing that comes up is that can create great friction between family members. Because now Susie is not just the supportive sibling, she's also the gatekeeper for the money, which Johnny can really resent. So I usually suggest 9 times out of 10, don't name the typical sibling as successor trustee. So you might want to name, you know, an auntie or uncle, but they may not be alive long enough. It might be a niece or nephew, but they may not have the skill or ability to manage this. So I often recommend naming a professional. And there's really 2 or 3 camps of different types of professionals that manage special needs trusts. One is a bank. There are banks and trust companies that regularly manage special needs trusts. Now, keep in mind, not all banks do, but some do, and some really specialize in this, and they can do a very good job. And they have the longevity. So you know that they'll be around, or if they're taken over by another bank, that bank will be around. So those are some great pros. Some cons to naming banks, though, is that they typically charge a bit of money. Right now, it's about 1.25% perhaps of the assets under management in the trust per year. So that can deplete the assets. Also, some people think that banks can be kind of cold and not that friendly, but a lot of times do keep in mind that banks can have care managers under staff, or they might hire out for another care managing company to help interact with your child. So they can take care of that part. The other possibility, the other camp of who could act as trustee, there are people called private professional fiduciaries. And these are individuals who are licensed by the state of California who do a really good job managing assets. And this is what they do professionally. Okay, so private professional fiduciaries, or sometimes I call it PPF. So I always recommend interviewing people. You know, private fiduciaries, they might charge hourly, or they might charge a percentage. It depends on who you hire. One of the drawbacks of them is usually they're about your age or maybe a little bit younger. So they're not going to be alive for the child's lifetime. So you need to make sure that they have a good succession plan in place. Also, it's good to hire a private fiduciary who's nearby your child. So if your child moves, that could be a problem. Now, If you choose to name a professional as successor trustee, one challenge you might have is maybe you don't know that professional that well. Maybe you've named a bank, and are they really going to do a good job? Your child has disabilities, so they really won't be able to advocate for themselves, most likely. So this is where the disabled child's sibling can come into play. What I think is a great role in the example we gave with Johnny and Susie, a great role for Susie is acting as trust protector. So this is a person who gets yearly accountings. They get to see how the money is being managed and distributed, and they have the power to remove and replace the trustee. So if things aren't working out well with the trustee is being too stingy with the distributions, or just isn't being communicative with the disabled beneficiary, or just something's gone off the rails, then the trust protector can come in, talk to the trustee, and basically threaten them and say, hey, if you don't clean up your act, I'm going to remove you. And they give them a chance to resign. Or perhaps the trustee then cleans up their act. So I feel like the trust protector is a really great oversight opportunity. It could also be another trusted family member or a friend. So it's really just a once a year role. And also they don't have fiduciary responsibilities. Under the California Probate Code, the trustee is really supposed to do a lot of things right. They're supposed to manage the money properly. They're supposed to give accountings. They're supposed to do all these things. The trust protector does not have those responsibilities. So their role is really limited. And that can be great for someone who's really busy or just doesn't have the expertise, but they still can make sure that things are going well for your child and money is being managed well. Your child is living their best life. If this information is resonating with you, I ask you to please hit the like button below, as this helps get the information out to more and more families. So there are several types of special needs trusts depending on the situation. The most common special needs trust is something that we call a third-party special needs trust. So this is a trust that, say, a parent or a grandparent or a loved one sets up for the disabled beneficiary and then funds that trust. So the money going into that trust is from third parties other than the disabled person. That's why we call it a third-party special needs trust. So compare that to a first-party special needs trust. That's a trust where the disabled person puts their own money into the trust. It's the first party's money going into the trust. Now, the third-party special needs trust is actually more beneficial in several ways. The first way is that upon the beneficiary's death, all the money goes wherever the trust says. So when you're creating the trust, you have to think of what happens when the disabled person dies, and then you spell it out. You say, well, it goes to this person, and if they're not alive, it goes to this person. And all of the money in a third-party special needs trust distributes that way. Whereas in a first-party special needs trust, Medi-Cal wants their money back. So if Medi-Cal has paid out money for the disabled person's benefit, then when the disabled person dies, they bring a reimbursement claim, and they get as much money as they've spent out during that beneficiary's lifetime. They get that money back. And then if there's any money left in the trust, then it would distribute to wherever the trust says. So sometimes the beneficiaries have two trusts set up, a first-party special needs trust holding their own money and a third-party special needs trust holding the parents' money that they've given. Well, in that case, which trust do you think should be spent down first? Where should you spend your money out of? Yes, the first-party special needs trust, because that money will otherwise, a lot of it will go to Medi-Cal. So that's the money you want to use first. Another limitation with a first-party special needs trust is that it can only be set up by certain people. It can be set up by the disabled person themselves if they have capacity. And that's something pretty new. Only in the last few years has that developed as of the time of this recording. By the disabled person themselves, by their parent or grandparent, or by the court. So a friendly aunt cannot set up a first-party special needs trust, whereas a third-party special needs trust can really be set up by anybody except for the disabled person themselves. So a family member or a friend. So if you know of a family member who needs a special needs trust. A lot of times I'll have people come in and they have a grandchild who's 5 years old and has recently been diagnosed on the autism spectrum. And the parent is just trying so hard to provide resources to that child that they can't get their estate planning together. So as a grandparent, you may choose to set up a special needs trust for your grandchild. And then the child can also fund to that. So that also brings up another point I'd like to talk about is, how should the trust be drafted? Should the trust be drafted as part of your revocable living trust, or should it be a standalone, a separate special needs trust? Well, just about all the time, I recommend having a standalone special needs trust. Let's think about that example that I just gave about grandma setting up a special needs trust for her grandson. Well, if it's a standalone special needs trust, then that trust at any time can be funded. So grandma's money can go straight into that special needs trust when grandma dies, or if grandma wants to make some gifts, that's okay. However, if you have a testamentary special needs trust, then that trust doesn't spring into being until the parents are gone, until the people setting up that revocable trust have died. So it's not available until it springs into being, which is really a problem if you have other family members wanting to fund. But I think the real benefit, even more, of having a standalone special needs trust is this. When you die and the trust is funded, you need to report it to the Social Security Administration and the Department of Healthcare Services in California. If you have a testamentary special needs trust, and it's Article 6 of your full revocable trust, and you send this in to the Department of Healthcare Services, they're going to look at this and say, well, what is this? They don't specialize in reading trusts. They don't know where the special needs trust begins and ends and where other trusts begin and end within this trust. They're confused. Sometimes they even ask us as attorneys to cut and paste and just provide those. But if you send them the standalone special needs trust, you just send it in. You say, here are all the terms, and they're very happy. And we want to make the government as happy as possible and let them approve the special needs trust so that the child can continue to receive the public benefits that are so important. So let's say that you set up a revocable trust a while ago, and maybe you had one child at that time, and since then you've had another child and that child has special needs. What do you do with your current revocable trust? Well, what we usually recommend is you do something called a restatement and amendment. So this is where you keep the title of the revocable trust the same, so you don't have to retitle all the assets that you've already put into the trust. You keep the title the same, but you update the insights. And in the revocable trust, you'll say, let's say you have Johnny and Susie, right? You say, so upon the death of the survivor of us, if you're married, then half goes to Susie, and then half goes to Johnny's special needs trust. And you give the name of that special needs trust. That's your standalone special needs trust that's located out here. And then they talk to each other. So it funds through the revocable trust out to the standalone special needs trust. So maybe you've set up a special needs trust a while ago for your loved one, and you're wondering, is it still valid? Because the laws change every so often in Congress and under California law. So I do recommend every 3 to 5 years, you go into an expert in special needs planning and you have them review the special needs trust to make sure that it still functions properly. And also, if you have a revocable trust that has special needs trust, a subsection with that, it's a testamentary special needs trust, then you might consider revising your revocable trust to make that section of your special needs trust now be a standalone special needs trust, because it does provide more flexibility and it also is easier for the government to review when it's time. For additional information on how to set up a special needs trust, I actually have a full-length webinar that goes into more details on this subject. So please hit the link below and you can access that webinar. Please also check out this video right here on how to hire a special needs attorney. So watch this video and I'll see you on the next video.